this was scheduled as a pre-trial conference because there were so many participants and some differing views and differing issues. And so I hoped we could kind of pare all that down, especially the issues. And I think maybe we've had another issue pop up since we were here last or not. So
we did, Judge. We've asked in light of the report from the medical provider that the court go ahead and appoint Mr. Richard Thomas as the acting and temporary conservator on this matter. In light of the report from the psychologist that basically said Rex Thomas did not have the capacity to do it. He was subject to undue influence. We're watching a lot of money go out the window as far as with all these different attorneys. I think the court is right. I think there was 5 different attorneys. These are not being paid for by anybody but the respondent on this case. The other thing, as far as an emergency, Your Honor, if we didn't have, the court hadn't issued the preliminary injunction, all this real estate, $4 million worth of real estate approximately, would be gone by now. So I think when you look at the money that's going out, this has always been contrary to Rex's estate plan until he was 95 years old. He's still collecting the payments, Your Honor, from the prenuptial agreement. So he's still getting all that. But then now that he's got, these issues that are really significant, truly really significant, we think it's really critical that the court go ahead and appoint the petitioner as the temporary conservator, at least. We think that's an important thing to do today at this time, given the report that we've got.
Ms. McDaniel, are you going to join us today or not? You're muted.
I'm here. Yes, Your Honor.
Let's leave your camera on when we're in court. I like to know where the people are.
I can do that.
Okay, go ahead, Mr. Simmons. Or Simmons. Somebody told me I pronounced your name wrong. Simmons?
Simmons, that's right, Your Honor, but I know who you're talking about.
Okay.
So that's our position as far as we think we've now got a ton of discovery. I don't know how much money they're wanting to spend of the respondents. I mean, we've got an enormous amount of discovery they shipped in yesterday. So we've got an enormous, the costs are extreme on this case for somebody who's got really significant impairments. I think the report said a 2nd grade ability to do math approximately. So we've got some really significant concerns. We're seeing a lot of money go out the window. The other thing I would just point out, I have not gone through all the records, and I just bring it up because it was in Mr. Rosen's answer where it looks like he's saying that the Dr. Basham, who didn't do the reports while we had the report in the first place, basically he was saying, I can't remember exactly. He was saying, can't remember exactly what his exact argument was. I'll probably remember as we keep going. Oh, the bank records, or something about the bank records. Something about us not responding quick enough with the bank records. We are going through those. There is a lot of them. There's 500 some records. But the other thing we've noticed, Your Honor, my client, I haven't gone through them all, is that they're saying that we're missing certain checks, certain deposits, certain things. So we don't believe we're still getting all the records. We think it's really critical to the estate here that we get Mr. Thomas in as the acting conservator, so somebody can go in and investigate the transfer. I mean, there was one transfer before the court shut it down to a trust of Mr. Thomas's property. So they transferred it to a trust, which was contrary to his entire estate plan. The other thing that's important about this transfer is it gives Tina, the wife, who wasn't supposed to get anything under the estate plan, it gives her the ability to totally revoke, amend, change the terms of the trust at any time. Plus, the acting power of attorney is now a beneficiary also under that. So we've got some real concerns with this. We think having Mr. Thomas, we understand that they think he's got some type of nefarious motives, but he's the one that's actually spent thousands and thousands of his own dollars hiring the doctor, getting this stuff set aside that's clearly been beneficial for the estate, given Rex Thomas's condition. We think he is a perfect one. The whole family, Arnold's here, he's nodding his head. We think Mr. Thomas is the perfect one to have appointed as the temporary conservator, and we think it's absolutely required.
If I recall correctly, at the last hearing, it was presented that Mr. Thomas, who, as you say today, has a $4 million estate, was crying to his son that they were going to have to sell land because he was so broke he needed the money to survive. Am I remembering that correctly? That Rex Thomas was led to believe that, or in his own mind created that? I'm not sure.
I'll let my clients answer that, Your Honor.
Yes, ma'am, that is correct.
Okay.
That's part of what precipitated all this, because my client has farmed with his dad his whole life. And so when he's hearing these, and he'd put money in his dad's account, when his dad was saying these things, he became very concerned about what was happening to his dad.
Okay.
That's right.
All right. Now, last time we were here, the wife Annette was here. She was, oh, that's your client's wife, excuse me. Let's see. Annette Thomas, Arnold Thomas, Rhonda Thomas, they were all here. I'm trying to figure out why all these people that were here last time weren't back here today.
So I don't know if there is, like I said, there's a lot of attorneys here. I think there's one of the firms, and I forget the names of all the firms that Rex has now on this case. I don't think
Yeah.
they've actually withdrawn, but I know, and that's the other thing. I think it was like $6,000 or something that they'd already paid this other firm. So we're seeing a lot of money, really, and I don't know what, Miss Perner's firm, where they're at with this, but this is a lot of money that we see, with a lot of attorneys. That's, is Miss McDaniel going to pay this back? I don't know. My clients would like to ask her to pay it back because they don't think it's beneficial for the estate at all, given Mr. Thomas's condition.
Well, let me check in. Ms. Perner, you were here before. And remind me, are you you're with Triplet, Wolf and Garrettson, is that right?
I am,
Co-counsel?
Your Honor, and I did not appear prior to this. I believe at the last hearing, Mr. Rawson was here from my firm, which is Triplet, Wolf and Garrettson. The lawyers at Martin Pringle, and that would be Garrison Matthews and Martin Bauer, have withdrawn from this case.
Okay,
Since the last hearing, Mr. Rawson and I and one of our summer clerks met and had a very lengthy meeting with our client. And I'm prepared to speak to the petition that was filed for the appointment. I think he meant an emergency appointment as opposed to a temporary. There are both of them now under this new act. Whenever your honor is ready for me to address that.
I'm not quite there yet, but I will soon. All right, so did both the attorneys, I knew that Mr. Garrison they were saying he may have to withdraw and be a witness, but you're saying both attorneys withdrew?
Both attorneys have withdrawn, and
Both
Mr. Thomas has hired my law firm.
All right, now your law firm was here last time, as you said, and Rex Thomas himself came in and hired you?
That is correct, Your Honor.
Have you met Mr. Thomas?
I have, Your Honor.
All right, I was surprised. I know I saw documents referencing this evaluation, but I don't know why I thought I'd get a copy of that. Do you all have copies of that evaluation that was done between the last hearing and today?
I've got a copy of it, and it should have been filed, Your Honor.
Maybe I just
It
missed
is a confidential filing, of course.
Well, Missy, do you know if we've gotten that anywhere? I didn't see it. I don't know if you looked for that when I mentioned it to you, Missy. Missy
Yeah.
being my assistant.
I looked in here, but I did not see it.
Could you check with the clerk and see if maybe they put it somewhere else since it is confidential?
Well, it would have been electronically filed, so it should be in the file, but sealed.
Yeah, in the judge's file, right.
Yes.
And you didn't see it, I didn't see it, and Missy, she's pretty good about finding things, so. If any one of you personally filed it or your staff personally filed it, let me know because I'm not finding it in the file.
I did not, Your Honor. That would ordinarily, at least in my practice, be the petitioner's responsibility to file. So my apologies. I certainly could have one of my staff members, I could step away and have them file it quite quickly or send a chamber copy to you.
Yeah,
It's a lengthy report.
that's why I was hoping I'd get it before the hearing so I could study it. Mr. McClendon, you got a copy?
Yes, Judge, I have, and I apologize. I I should have thought to file it beforehand, and I did not.
All right, well, so someone said Dr. Basham was going to counter remind me the name of the evaluator. I want to say Benson, but that's not.
That's right.
It is Benson, all right. I thought somebody said Dr. Basham, our local physician, was going. I'm sorry. Was someone trying to say something, Missy? Okay.
I don't know.
Okay. All right, go ahead, Mr. Simmons. You were going to say something there?
Oh, yeah. No, Your Honor, I was just going to say, I'll have my assistant file it right now. We did get it, and maybe it was just a miscommunication, but there is I thought it was going to be filed by Mr. McClendon, but I'll get it filed right now.
All right, if you would get it filed and maybe get a copy, as Ms. Perner said, get a copy over here to me through Missy, she can print it for me.
I'll have her email it too right now.
All right, that's great. Okay. All right. So Mr. Simmons represents the petitioners, the son, wanting to have this temporary emergency guardian, or in the alternative, just guardian conservator. Are you looking for guardianship or just conservatorship? You're muted, sir.
The report basically indicated that Mr. Thomas could do some basic living functions, and he could potentially utilize a power of attorney for that aspect of it. But he did recommend a full-blown conservator, especially on the financial aspects. So that's what we thought as far as an emergency basis, based on his report, that it was required immediately. That being said, there is the allegations are that he's subject to undue influence. He does require help kind of going anywhere, doing anything. So I think he's going to need a guardian as well at some point. It's just with the report when it came in, it indicated that there was a need right away for a conservator. So that's why we asked for the emergency motion on that, at least so we can get stuff squared away. We need to investigate it. We need to look what went into the transfers of these tracts, at least one tract of land to this trust. We need to look about, make sure we've got all the records, the checks, things like that. So that's really what we need to do on a kind of a basis right now.
All right. Now, Ms. Perner, you represent Rex Thomas only?
Correct.
What is his position? Do you believe he's able to make decisions on his own, or what is his position?
I believe the day and the time that I met with him that he possessed testamentary capacity. Now, of course, the test, and I think it's going to be very important for Your Honor to have an opportunity to review this report. I do not interpret the report to conclude what Mr. Simmons concludes it to report. And of course, I've read many of Dr. Benson's reports. He does raise concerns about the potential of undue influence. He does conclude that but for other protective arrangements, in other words, a durable power of attorney, that the appointment of a guardian and conservator would be appropriate. Now, I think that it's quite important to remember that with the changes, the massive changes of this statutory framework that went into effect, that unlike our old code, and I've spent a little over 6 years on the committee that wrote this new code. So, don't shoot me, but that's one of the primary things about this is that a guardianship and a conservatorship is a last resort. And so if other protective arrangements, if an individual possesses the capacity to put in place other protective arrangements, which include powers of attorney, which include trusts, that be honored and that we not be in this public spectacle. Now, another thing that this code permits, that the old code did not permit, is the attack of the validity of estate planning documents during the lifetime of the individual. And that's what the petitioner is trying to do here, is test the validity of the documents that were drafted and put in place by the Martin Pringle firm and by Mr. Thomas. I will tell you that consistent with the Martin Pringle's reports to this court, and consistent with the report that Mr. Thomas made to Dr. Benson, that his desires with respect to his estate in the event of his death are consistent across all three of those planes. And so there is a temporary conservator that can be appointed under the new code, but that is not what we have here. A temporary conservator is contemplated only after a permanent guardian or conservator has gone in. I think that what the petitioner here is seeking is the appointment of an emergency conservator. And in order to enforce the importance of robbing someone of their civil liberties and their rights in these cases, for example, under the new code, under the emergency appointment powers, unlike our old code, it is required that an individual be served with process if they are not given notice, a little different than what we've got going on here, but within 48 hours. And you have to have a hearing within 5 days if you have an ex parte hearing. Well, here we've had about 72 hours, and we've got medical records that are beginning to come in. In our answer and written defenses, which is on page 4 of that document, paragraph 11, we address Dr. Basham's opinion. And Dr. Basham, in his notes, says that he spent about 30 minutes with my client, and his notes state, quote, informed his score at 28/30, and it shows that he does not have dementia, period. He has a little bit of forgetfulness, which is not an issue, period. Medically not demented, end quote. So to me, the appointment of an emergency conservatorship is completely inappropriate. This court, during the last hearing, appropriately entered, pursuant to 5930-163, an order to preserve and apply property while a petition is pending. And what the court's order provided, we address that in our answer and written defenses, is that the money is to be used in a way that is contemplated by the prior reference statute. Now, in order for the court to make the appropriate findings that would allow the appointment of an emergency conservator, the court must look to KSA 5930-172. And the requirements that this court must find are as follows. That appointment of an emergency conservator is necessary to prevent imminent, substantial, and irreparable harm to the individual's property or financial interests. And that, number 2, no other person has authority and willingness to act in the circumstances. And 3, a basis for the appointment of a conservator thereto exists. Now, number 1, we've got no evidence in front of the court that would suggest that there is anything further than the orders that have already been entered by the court pursuant to the previously referenced statute to prevent imminent, substantial, or irreparable harm to my client's property. Number two, my client has made a decision as to who he wants to have help him manage his property. That individual is managing that property. As a matter of fact, my client spent, as it was pointed out by Mr. Simmons, in excess of $6,000 paying a lawyer to avoid having to be the subject of litigation of this nature. And yet here we are. And number three, he has to demonstrate that there is a basis for the appointment of a conservator. Here, there is not. There is an appropriate other protective arrangement in place, namely the powers of attorney for health and the powers of attorney for finance. And I do believe that it's interesting that these sons, apparently both of them now, although only one has formally entered an appearance in this case, that apparently both of the sons are quite interested in the conservatorship aspect of this and in challenging the validity of the financial things that their father did. And yet neither one of them are stepping up to take care of his day-to-day medical needs and concerns. Neither are challenging his living arrangement, etc. And so even if the elements are met, which I don't believe that they are met, and frankly, I'm a little, to have an individual pay a lawyer to put in place the necessary paperwork to avoid having to be a person subject to a guardianship and a conservatorship in a very public kind of way. To have that challenge down the road is on some level offensive to me, but it seems to me that the very first inquiry that this court has to make is whether or not the papers that were drafted by the Martin Pringle firm and signed by my client are valid. If they're valid, it's game over. And Mr. Simmons wants to talk about there being a prohibition in the premarital agreement as to somehow Mr. Thomas not being able to make a decision to divide his estate equally. Well, to the contrary, that's not what the agreement says. He has got the ability to change and modify how he wants to gift his wife, or anyone else for that matter, his estate. You know, and after 23 years of marriage, does it surprise me that maybe he wants his wife to be cared for in a different way? I don't think so. And to tack back, Your Honor, and I'm sorry, I feel like I'm kind of wandering around in this argument, but even if the court were to find that the emergency conservatorship is appropriate, which I don't think there are facts in front of Your Honor for you to be able to do, the 3169A tells us what the priority of the appointment is. And the priority is not the son. The priority is the person that is in a recent nomination of a power of attorney. So we do indicate, and Ms. McDaniel is here, she can speak to this, but my client would certainly direct her on a monthly basis to file whatever report is necessary to be filed with the court, or to provide it with Mr. Simmons and Mr. McClendon. I can't, you know, Mr. Thomas doesn't have a problem with that. He is comfortable with who he has selected to have him assist him in his financial matters. And he doesn't want his sons to be that person.
Your Honor, I have a couple things. I don't know if you want Mr. McClendon to respond, but I'll have a couple things I'd like to respond on that.
I would like to hear from Mr. McClendon next, please. Mr.
Yes.
McClendon, have you actually met with Mr. Thomas?
I have not since our last couple meetings, Your Honor. However, in reviewing the report, I do recall there being a moderate level of undue influence or a moderate risk for undue influences, I believe how it put. So does that mean there was undue influence? I don't know, Judge, but he was moderately susceptible to it. Probably more than most is what the way I read that. Additionally, Judge, to counter what Ms. Perner stated was, well, you know, Mr. Thomas wanted Ms. McDaniel to be his power of attorney originally, Judge, and I believe the court's heard testimony from Ms. Shirley to this at some point in an earlier hearing, but originally that wasn't the case, and that's why the Pringle firm was hired, Judge. So, and then not to mention who's the one putting up putting up, yes, it probably came out of Mr. Thomas's estate, but who's the one forcing the hand? Hence the case for undue influence. So, Judge, I think we probably need to have a hearing on this. There's probably more discovery that needs to exchange hands, but I kind of share the same opinion as Mr. Simmons. I don't know who we would appoint. I think one of the sons, just to get a fresh set of eyes on things, would be appropriate. Now, I'm not saying for medical as well. I don't know if they'd be willing to, but for a conservatorship basis, I do think that would be appropriate because we've had red flags of financial issues in the past coming from his stepchildren, who, as the estate stands right now, have absolutely nothing to inherit, but are trying, I say trying, but with the rearrangement of the estate, have $4 million plus to inherit. That, and to consider, reading over 593172, imminent, substantial, or irreparable harm to the individual's property or financial interest. $4 million isn't substantial. Selling property isn't irreparable. I'm sorry, Judge. I think there is an emergency basis there, and that would be my argument to such, Your Honor.
So this emergency conservator would, as you're proposing, act until we have full hearing on whether there's a need for the temporary would be until we can have a hearing for a conservator.
That's what we'd ask for, Judge. And as far as the reference that the Dr. Rosen might have not have said that he had capacity, I can't remember exactly what you said, but he specifically said he does not have the capacity or ability to manage his estate. I mean, the court can review that, but that's pretty clear. He doesn't have the capacity. As far as the guardianship, the report says he had, with the assistance, he could use activities of daily living. Dr. Rosen was considering the alternatives available in this situation. So he was considering the alternatives, but he didn't indicate he said that would be with a trusted individual though. My client's obviously more than willing, if we want a temporary guardian, my client's more than willing to be the temporary guardian as well. We just saw that, like Mr. McClendon said, not only does he not have the capacity, but then it says he requires assistance with financial management and demonstrates increased vulnerability to financial exploitation and undue influence. We saw, and Your Honor, we've seen the fact pattern. So Ms. McDaniel can say what she would like, and they can make those arguments, but we saw what happened shortly before the last hearing. Not only did they transfer one tract to a trust, they had transferred another one. Like the day before the hearing, they tried to transfer another tract of land, and then they had it set up for auction like the very next day. If transferring this property and this land if that's not an emergency situation, I don't know what is. The other thing is there are checks that are written that are not it looks really apparent that it's not Mr. Thomas's signature on some of these checks too. I'm not full disclosure, I'm not an expert on handwriting, but you can look at these checks and tell there's not not Mr. Thomas's handwriting. So we've got some concerns with some of the checks being written. We haven't gone through all those records, but there's a lot of concerns here of things that are just adding up, just piece by piece, that provide the court more than enough basis for an emergency hearing. As Mr. McClendon said, as far as maybe, the argument, maybe he decided now after, 95 years, 96 years, whatever he is now, that he wants to change his estate plan. That wasn't his idea just a few months ago when he had, Mary Ann Shirley. You heard that testimony from Mary Ann Shirley. Everyone consented to it. She said he wanted Richard to be his power of attorney, and he wanted to do transfer on death to Richard, and they all got mad and stormed out. If that doesn't signal undue influence, I don't know what does, Your Honor. So we do think there's an emergency basis. And like I said, my client, he was the power of attorney for his dad for many years. If the court thinks it's appropriate to do the emergency guardianship too, he'd be more than happy to do that. He's retired. He still farms, but he'd be happy to do it if the court wanted to appoint him as both emergency guardian and conservator.
You said he was his power of attorney for years. You mean that in the legal sense? I thought Ms. McDaniel was his first power of attorney.
No, he was his power of attorney until Mrs. McDaniel took it over just recently. Correct?
Yes.
Okay, so
That's when Miss McDaniel took it over.
is that
and-
Richard Thomas that said that Richard was the power of attorney?
Yes, Your Honor.
Yes, ma'am.
All right. So let's narrow down you want a you're petitioning for a guardian, no, a conservator. That's what started this, was the petition for conservatorship, regardless of whether we need an emergency one, correct?
No, we did a petition for a guardianship and conservatorship. We actually did a petition for both of them. We think that there's significant issues. We just didn't think we had, with the report, it looked like there was potentially some alternatives that Ms. Perner briefed the court on just a moment ago. But we thought with the report saying he didn't have the capacity to manage his estate, plus the undue influence and exploitation, we thought we had to take action.
Well, what about the provision that if he does need a guardian conservator, should I not look to who he had appointed to power of attorney? Is that not in the statutes? That whoever he appointed should be considered?
Well, and you can consider those, Judge. What you're trying to do is figure out who's in the best interest of the estate, who's taking the best actions for the estate. So you can consider those. But Mr. Thomas was, and that's who he directed. That's what Mary Ann Shirley said, that he wanted to be his power of attorney before apparently he might have switched it. But we do know he's got significant, potentially even Parkinson's. I mean, he's got a lot of issues going on. And it said there would be have to more testing on some of those things. He's got a lot of issues. And so Mr. Thomas was somebody always that had been a power of attorney until very recently. But the testimony was not only do we have a power of attorney, but Ms. Shirley was a power of attorney. And those are the things for the court to consider as far as who's going to do what's in Mr. Rex Thomas's best interest here.
All right, Mr. Simmons, if we set this for trial, what issues do you see needing to be resolved?
Your Honor, I think we've got a lot of the information. I mean, we are going to have to investigate. I think the transfer, obviously the transfer that's changed. So the issues are undue influence, capacity, I think the medical report indicates that he cannot manage his estate. So I think there's clearly a need for a guardian conservator, at least a conservator, based on the doctor's opinion. But I do think we're going to have to investigate that transfer, because at least one transfer has gone to this trust, which was not consistent with Mr. Rex Thomas's longstanding estate plan. And like I said, the current power of attorney is a beneficiary who had never been a beneficiary before. That's the other thing too. She'd never been a beneficiary before, and now she's a beneficiary.
And she became a beneficiary through the trust?
Right, through this trust that was just created in March of 2026, after she was the power of attorney. So after March 2026, she became a beneficiary of this property that Mr. Thomas has, after previously never having an interest in it.
And Ms. Perner, what issues do you see at the trial needing to be resolved?
Your Honor, if I may, before we get to that, just briefly, back to this emergency appointment.
Well, I was putting that off, but go ahead.
Yep. Okay. We'll
Go ahead.
put it off. To me,
No, you go ahead. Go ahead. That if you want to bring that up now, go ahead. If you think that might have some bearing on where we go from there, sure.
Yeah. to me, the temporary, it requires imminent, substantial and irreparable harm. I don't know how you meet that test in light of this court's orders and the reports that are going on. I don't see where the imminent, substantial, irreparable harm can take place in light of the previous court's order pursuant to KSA 30,133, which is an order of preservation of the property. That's all I wanted to say. Your Honor, I think that Mr. Simmons is right. I think this is a case where the sons are challenging the validity of estate planning documents, and if those documents are valid, there is absolutely no basis for guardianship conservatorship, period, end of story. And so we've got the discovery that needs to be done, depositions that need to be taken of lawyers. We propounded written discovery yesterday. There will be fact witnesses, including the sons. My guess is Mr. Simmons is going to want to take the attorneys in fact, and will want to take my client's depositions as well, the individuals that have been involved in the real estate sale that the court put a stop to, and of course the doctor, Dr. Benson, the PhD, and also the medical doctor will need to be deposed. And, you know, the undue influence, it's a big tent concept. Capacity is one of those, and relationships. It's a very factually intensive thing. But I think that before you can get to the issue of whether or not Mr. Thomas is in need of a guardian or a conservator, you have to figure out whether or not he put other appropriate alternatives in place, i.e. his trust and his powers of attorney, in March of this year. I think that's the nut of the question, and I think that's the next question that has to be answered. If the answer is that they weren't appropriately put in place, then the guardianship conservatorship is appropriate to proceed. If they were properly put in place, game over. That's my analysis of it. Mr. Simmons and Mr. McClendon might see things a little differently.
And if the power of attorney that he put in place, if he put someone appropriately in place and that person is misusing his assets, selling stuff they shouldn't be selling and misusing it, what would you suggest the remedy be?
Well, there are lots of remedies for that. That would be a monetary damage, but there are lawsuits that can be brought. I've brought them before under the our version of the Uniform Durable Power of Attorney Act. You know, this court has all kinds of powers under that act in and of itself, and there's a statutory penalty that attaches with the misuse of an agent, of a principal's assets.
Like someone who's becoming a beneficiary?
I'm not sure I understood the question.
Okay, so maybe there is another issue too then, Judge, whether we got additional violations of the Uniform Power of Attorney Act then too.
Well, that
Mr.
would be
Simmons?
the principle that, well, Mr. Simmons, I'll let you make whatever arguments you want to make. Amend your pleadings however you want to amend them, although I think that would be a Chapter 60 action and not a Chapter 59 action. So there are remedies that are available when you've got an attorney, in fact, that is behaving badly. That's contemplated in our Power of Attorney Act. Does that answer your question, Judge?
It does. I think what I'm hearing is that you think that they're using the wrong they're going about it the wrong way, what they're trying to accomplish, maybe. If they think the folks appointed power of attorney are mishandling their responsibilities, there are other avenues they could legally pursue rather than the power of going after a new guardian.
Not necessarily, Your Honor.
Okay.
Okay, I think that that is one avenue. I think there are a couple of tracks that they could have brought an action on. And this, under this new code, it is now possible, and it was not possible before, to challenge, during the lifetime of an individual, the validity of their estate planning documents. So, you'll remember that that was just something you had to wait till people died to do it. And this is something that can be done now. But if the challenge, if you take a swing and at the validity of these documents, then the documents are found to be valid. In other words, that Mr. Thomas had the testamentary capacity on the day that he signed the documents at Martin Pringle, then it is not appropriate for the court to appoint a guardian conservator, a limited guardian or conservator, or engage in any other protective arrangement under the Act. And that is to some extent, other than the challenging during the lifetime that these estate planning documents, that's consistent with the old Act. If there were, under the old Act, if there were other appropriate alternatives in place, which is in the definitional section of that old Act, it included trusts and powers of attorney. It's the same thing here. So it tacks back to, are these valid documents? If they are, then a remedy of a guardian and conservator is not available to the court. If you've got an attorney in fact under the Power of Attorney Act that is misusing or abusing his or her powers, there are standalone statutory remedies that are available to litigants.
So as Mr. Simmons said, capacity may be issue number one. As you just said, did he have the capacity to, or does he have the capacity now? Did he have the capacity when he made the appointments?
So the one thing I would remind the court is that he does have, I think at least 3 or 4 tracts of land still that were not transferred to the trust. There is going to be a need for a conservatorship. There's one tract of land that was transferred to this, to this trust supposedly. As far as understanding who signed off on that, what was he under the impression when he did it, there is some factual details in it. I don't think you get to say, well, he transferred that, so bad, too bad, so sad. You don't get a chance to, try to bring that back on behalf of the estate, which again shows exactly why we need to, Your Honor, because somebody's got to investigate this on Mr. Thomas's behalf. The perfect one to do that, the perfect one to truly investigate this is Richard Thomas on his dad's behalf. I think there's clearly enough evidence here, Your Honor, for an emergency situation right now.
All right.
Your
Go ahead.
Honor,
Go ahead, Ms. Perner. I'll let you make your final comment.
Yeah, I'm representing Mr. Thompson. He's got a power of attorney in place. He is elected to put Ms. McDaniel in his attorney in fact. It doesn't matter whether that land is titled in the name of the trust or not, or whether it was conveyed or not. He has put in place arrangements to keep us out of this type of litigation. And until the court can find, through undue influence, lack of capacity, that he lacked the testamentary capacity to properly execute those estate planning documents, it is not appropriate to appoint somebody who he has expressed to his previous counsel. And I believe that this was addressed in Dr. Benson's report. It's not appropriate to substitute the son's judgment for my client's judgment. And with that, Judge, I'll shush. I think you heard enough.
Well, it does seem that Ms. McDaniel may have an interest of her own in this through the trust. Mr. Richard Thomas may have an interest in this for himself. Is there any proposal for an emergency conservator that would be appropriate without a personal interest in it? Because I am concerned that there is an immediate need to protect this gentleman's property, that $4 million, as Mr. McClendon, I think it was, said, that is a substantial amount. And it certainly, if we sell the land, as the conservator's been, or the power of attorney, in fact, has been wanting to do, it is irrevocable. Once the land is sold, it's sold. So I'm finding that there is a need for an emergency conservator, but the question is, who would that be? If I appointed Miss McDaniel, as Mr. Rex Thomas has in the past apparently felt appropriate to handle his property and his estate and acts in his stead, I still have the same concerns that the property is at risk, that his estate is at risk. So is there anyone that wouldn't be directly benefiting from acting in the role of conservator? At least
Your
on the.
Honor, I would want to talk to Mr. Thomas, and next week I should be able to go out and sit down with him and meet with him about this.
Talk about Rex or
Frankly, with this pending litigation, nobody can sell this property. There's a huge cloud on the title. So I'm not sure I understand how there is something imminent out there, not to mention the fact that the court has ordered that everyone stand down on all of this. We've got Liz Pendens that's on the land as well. But having said that, if you're going to put anyone in, there is one bank with trust powers in the state that has an in-house farm department. And it would be my suggestion to my client that bank be appointed if the bank is willing to do it.
Mr. Simmons, Mr. McClendon. I'll start with Mr. and Mrs. Simmons.
I guess, Your Honor, again, we're just talking about more costs, fees, hiring another person, hiring more attorneys, things like that. I guess the one who can do it, I mean, the court gets to monitor. Part of the benefit of having the conservatorship is the court's oversight of it. The court will have, oversight, special accounts. Court knows what's being spent on this thing. I don't know. I guess, my clients, I think he's still in the best position. I'd want to know, again, what the charge was, who they're looking to employ, who are they going to look to hire, because they're going to spend a lot of money on this case, Judge. And so what we're trying to do is preserve the estate as best we can. It needs preserved. I think the court would have sufficient oversight on this thing, with my client being the conservator. I think he's the right one. I don't know what Mr. McClendon's position is.
Mr. McClendon?
Judge, I think as long as we have the injunctive relief on the property where we're not selling anything, and then if we make the conservator provide financial accounting before each hearing. Again, that's going to be costly for someone, but as long as we maintain court oversight on that and make sure we're not going awry. I understand both arguments here, and I think from an investigative purpose, to maybe flesh out some other potential misuse of Mr. Thomas's funds, I think Richard Thomas would be a proper conservator in these regards. And I think that would be one purpose for appointing him. However, um, on the other hand, I believe Carla, Miss McDaniel, is a little more involved in maybe some of the day-to-day caretaking, which may make her a better case judge. So honestly, you know, I'm kind of leaning towards, if I had to recommend one, I would lean towards Richard Thomas, Your Honor, and that's for investigative purposes. Judge, but otherwise, I think I'd be pretty split on the matter.
How about co-conservators? Ms. McDaniel and Richard Thomas, would that be totally crazy?
I
Or they'd agree
don't-
on how to spend the money, but
That's what I'm thinking. They're definitely gonna represent their own individual differences, and maybe they could come together for something that would be appropriate in the middle. Just throwing that out there to see what the response would be.
Your Honor,
So-
Your Honor, this is Carla. May I speak for just a moment? I know I'm not an attorney, but would just like something on the record.
Sure, go ahead.
Okay, just a couple notes. I just want to real quick get on the record is that I did provide all the information. I just want to let the court know I did provide all the information that was requested by the court. So I sent over all the financial documents. So not only did I send over grandfather's information, but my grandmother has some accounts in her own name. And for full disclosure, I provided those as well. So I have sent over everything that the court has asked. And I've also sent over whatever medical documents the court has asked. So I just wanted to make sure that that was on the record for the court. And then I also want to just mention that that I know that there are a lot of accusations out there about the current POA, which is myself. But I also want to point out that no one has spoke with me yet. No one has got my testimony yet. And so I do not know where they are getting some of these accusations that they're making. And then the last thing that I do want to say is that just remind the court that Mr. Rex Thomas is my step-grandfather, and that he has been my step-grandfather for 24 years now. So it's not that I'm just a POA, but Mr. Thomas is my grandfather and he considers me his granddaughter. I know that Richard and Arnold did not have children of their own. So my grandfather inherited some grandchildren when he married my grandmother. I am the only grandchild that lives in the state of Kansas. And I've just been blessed to be able to have a relationship with my grandfather, and that he could have that experience of knowing what a granddaughter and grandfather relationship is about. So I just wanted to make sure that the court can respect that and keep that in mind, that he is my grandfather and I love him very dearly.
Well, thank you for adding that. What is your thought about working together with Richard? Or is that just unthinkable?
I personally would not be opposed to it. I agree with Rachel. I think that grandfather needs to be asked, Grandpa Rex, on what his decision would be. I still see my grandfather very capable of making his own decisions. I provide very little financial support to him. I mean, he's able to do most of it besides, maybe helping him write a check because of his tremors. So, I would be open to it, but I do know that grandfather has mentioned before. I know that Richard was his POA, but it's my understanding, and I know I'm a generation removed, so I may not have all the facts, but he actually hired Mary Ann Shirley to terminate his POA because of an issue between them two, and I'm not even going to begin to get into it. And so Mary Ann Shirley's office actually sent and fired Richard Thomas as his POA. And then when it was time to go to Alliance and get their health care insurance or their long-term care insurance going, that is when a POA needed to be put in place. And that is when they asked Richard or Arnold. After they asked Richard, Arnold did not want it, it's my understanding. And so then they reached out to me and asked me, and I've been helping them, getting them set up on their long-term health insurance, and then helping provide support as I can. So I do not feel that my grandfather, knowing that he terminated Richard already as his POA, would care to have him part of his financial decisions. So I really think that someone needs to speak to Grandpa Rex about it.
So she just.
And that might be where we start next, because talk to grandfather. I keep hearing that grandfather doesn't need this, that grandfather can talk for himself, that he has no apparently trouble telling his granddaughter what he wants, what his attorney he wants. Maybe we just need to adjourn and reconvene when grandfather can be here. Miss Perner, what do you think? Can he come to court?
He could come to court. He's pretty
Yes.
stowed up. He's 95 and he gets
Mhm.
pretty nervous. And this whole process has made him very nervous.
Well,
But I absolutely would be happy to meet with him and arrange to get him into court to talk to Your Honor.
well, with this curiosity thing of Zoom court, we could even let him sit in his easy chair at home or wherever he likes to be, and someone can put the camera on him, and there we go. But
Well, I can do that. You know,
I
I'm
mean,
just,
I mean-
I'm looking at the requirements of an appointment of an emergency, and I just have got to take exception. I mean, the court has to find through affidavit or testimony that these criteria have been met, and I just don't know that any of that has been established. And I'm
Well,
happy to talk to him about, you know, does he want, instead of having the son or the person that he reported to other folks that he wanted in, which is Ms. McDaniel, if he's willing to have First National Bank of Hutchinson come in and manage this farm in the interim.
You know, I don't think Arnold was ever asked to be a POA. He's somebody that would be willing to do it. The report, you know, I think an emergency, again, I don't think we need to hit over that. I think it is important. I still think my client, if they wanted to try to do it together, have both of them agree on what the expenses are on, you know, Mr. Rex Thomas, that might be something if they could both agree to it. Again, I think the report's pretty clear that he's subject to undue influence. And I want to be careful with the testimony. The court's already heard testimony on this. You're going to see the report. Basically, it says he doesn't have the ability to manage his own affairs. I think we want to be careful. And if the court's trying to be careful, then we can appoint both of them, have them agree on all expenses on his behalf. And I think that protects everyone.
If
Well,
Grandpa
Miss-
Rex is good with it, I'm good with it.
well, Miss Shirley's testimony previously still stands out in my mind, but if I remember correctly, the family members were yelling at Rex, trying to make him do things that he was not wanting to do when they were.
Your
doing
Honor,
this.
I was at that meeting and that never happened.
All right, well, you're not under oath, but how about one other question? How about the investigation that was alleged that DCF was doing of abuse of a elderly person or a dependent person? What does anybody know the status of that investigation? Did that ever conclude or amount to anything?
Your Honor, the investigation that I'm aware of came back as unsubstantiated. We'll be issuing a subpoena so that Your Honor can review in camera, of course, those files.
Okay. I think Miss Shirley has testified that she actually is the one that made that report to DCF because of what she saw in her office. I don't know if you were here for that hearing, Ms. Perner. I think you told me you were not.
I wasn't. Mr. Rawson was there and he reported that to me, that she had called Adult Protective Services. And
Right.
as I said, if this is the same investigation, it came back as unsubstantiated. And we will receive those records after we issue the subpoena and Your Honor has an opportunity to do an in-camera inspection of them.
So just one thing I would add on that. I'm not sure if I believe you're right that they have unsubstantiated it, but I think what the report's going to show is that the family wouldn't allow an interview with Mr. Rex Thomas by himself with the investigator. So whatever color that sheds on it.
I haven't had the benefit of reviewing the DCF file, which is of course confidential, Mr. Simmons. Perhaps you have. But we'll all have an opportunity to see the work that was done and the reports that were gathered.
All right. Well, from my perspective, I need to hear from Mr. Rex Thomas and see if he's doing as well as what I think some of the parties are saying. This is all unnecessary. He can handle it himself. And if he's able to appoint Ms. McDaniel, if he was able to, and he did so voluntarily, then that certainly changes the color of everything. But if it is the result of undue influence that we have this situation, then we'll go in a different direction, of course. So I think before we start getting into too much, I need the doctor's report, which I'd hope to have by now. And Missy, did you ever get that by? Gosh, she's got it in her hand. Okay. But of course, I'm not gonna be able to crash read it. It is fairly substantial, it looks like, which is good. So I want the benefit of reading this report of Dr. Benson's and the results of the DCF investigation. And then I also want the benefit of meeting Mr. Rex Thomas and doing that by Zoom from his home. Miss Perner, you're his attorney. Can you set that up if we have a hearing date for that?
Your Honor, I can. We can coordinate with Missy and counsel and see what works for them. And we can certainly get on your Honor's schedule. And I would think that if not this week, very early next week, we should be able to get that it will actually be an agreed order that will circulate amongst counsel, that will allow all of us to have access to whatever it is that Your Honor releases after you do your in-camera inspection of the DCF records.
Okay. Mr. McClendon, how long will you be gone? When are you back officially?
I'm back in town next week, Judge, so I don't know what my schedule looks like without looking at it, but
Okay.
I'm sure we can get something nailed down the next week or two.
Okay.
Next week's not very good for me. I've got a couple of things next week. I've got several depositions and other things next week.
All right. Well, Missy, do you want us to try to figure out a hearing date, or Miss Perner, do you want to try to set, how do you want us to do this?
Well, why don't we, Your Honor, so that we're not hogging your time, we, meaning the lawyers, and get with Missy and find a date and a time that will work for everyone. I do want to add that regardless of the condition, we're dealing with different standards under the guardianship conservatorship versus the testamentary or ability to contract standard. They're quite different. So it doesn't surprise me, for example, that on a longitudinal basis, which is, the capacity that you look at in a guardianship conservatorship arrangement, that Dr. Benson concluded what he concluded. The analysis is going to be quite different for the court on the testamentary capacity, which is the instant in time, as Your Honor's well aware of what that standard is.
Mm-hmm. Yeah.
So if that's okay with Your Honor, what I'll do is send an email as soon as we end this Zoom call to Mr. McClendon and Mr. Simmons and Missy, and we'll set about getting something set up for an hour and a half. What do you think? And it's going to take us some time to get those DCF records. I would think it's going to take, probably 2 or 3 weeks for us to get those out of them.
Well, it probably won't take me much time with your client to kind of see where he is today, at least, the day I talked to him. And I understand that with some of did mention some things that different days that folks are on better condition. But I want to know him as a person. I want to see how he does present and if I'm able to talk to him in a meaningful way or not. But I would say probably an hour and a half, just for good measure.
Your Honor, in the interim, may I suggest that short of this temporary conservator, if Ms. McDaniel could take the steps that are necessary for the financial institutions to just release records directly to Mr. Richard Thomas, that might sate their curiosity about what is going on if they're able to go into the bank or the brokerage house and have authorization to access those records.
Mr. McClendon, did we lose you? There you are.
Sorry, Judge, I'm here. I was looking at my calendar.
Okay. Mr. Simmons, does her proposal work for you?
I mean, I still think it makes sense to put them both on if we're going to do something like that, so they can both agree to expenses. Again, they're spending an awful lot of money of this man's money on different things, and so I think it makes sense to put them both on for right now until the court has a chance to, talk with them. So at least we know that there's no, expenses that they don't all agree on until the court, until the court has a chance to visit with Rex Thomas.
Ms. Perner, did you give me your opinion on that code?
Your Honor, I think that in practice, I think it's a very good notion. And I have had it work on many cases before, but usually where they can act independently of one another. And I'm guessing that that's not what Mr. Simmons has in mind. I think it's going to be terribly clunky to have both of them signing off on all of the checks and seeing that the bills are timely paid. And if a need arises and it has to be met and one of them is unavailable, I don't think that it's going to be in Mr. Thomas's best interest, my client's best interest, to have something like that.
Well, they're not being timely met now because his taxes are due as of today from 2025. So somebody's got to do that.
His taxes are actually done. They've been done for weeks. Yeah, the taxes are done, so they're not overdue.
Real estate taxes?
I just want to make sure the court knows. 2025 taxes are done.
All right, I'll circulate that email when we get off the call.
I'll be happy to provide them to the court. 2024 as well.
So all of his bills are current, paid?
Oh, all his bills are current. I go out there every weekend. Everything gets paid. We review things together. Yeah, there's nothing late.
You go out there to Mr. Rex Thomas's house and go over all these with him?
Yes, I do. I live in Wichita. So I'm not in Eureka. Grandfather lives in Eureka. And if I don't go out there every weekend, I definitely go out there every other weekend. We usually go to lunch and I help clean or do whatever they need help. And then I will help both of my grandparents with what they need as far as paying their bills.
Do the grandparents still live together?
Yes, Your Honor, they do.
And what is grandma's condition physically and mentally?
Grandma's condition mentally is very good. The only health issues grandma really has is she has macular degeneration. And it has really gotten worse, a little bit worse over the last year. She is not blind, but she's probably not far from being blind. And she does have some hearing loss. So we would just need to keep that in mind with her during testimony or whatever, but she's in good health mentally.
And the other granddaughter, Your Honor, the other granddaughter is the power of attorney for healthcare purposes.
That is actually his step-granddaughter. I'm sorry.
Oh,
or his
no,
stepdaughter. Yeah.
His
My
stepdaughter.
Your mom.
Mhm.
And she lives just a few houses down. And so they're primary caregivers for these little people that are living on their own in their own homes still.
Okay, well. All right, so you're gonna get, Ms. Perner, you're gonna get the attorneys and Missy to give us a court date?
Yes, Your Honor. I will do that. I'll send that email as soon as I as soon as we get off the Zoom.
All right, well, rather than appoint emergency co-guardians, if you will, or co-conservators, I am going to leave the orders as they are now from the last hearing until we have the next hearing. But someone needs to tell me who's going to take the responsibility for the DCF records, subpoenaing them if necessary.
Your Honor, I've got an order, a template order that I can circulate. I'll take the laboring oar on that.
Thank you, Ms. Perner. And you're going to get your client available by Zoom for the next hearing.
Yes, Your Honor.
And I do now have the Benson report. I think that covers what we've talked about for the next hearing. And if by some chance you all would come to an agreement as to what is best, I certainly would welcome that. And then Mr. McClendon, you're going to do your best to get out and talk to Mr. Thomas personally.
Yes, I will, Judge.
All right. Okay. So let's have this next hearing as soon as Missy can fit it in and with your schedules and mine, and that's not always easy, so. But Ms. McDaniel, you do need to have accountability for how you're spending this gentleman's money. Don't be selling any assets without approval, particularly the real estate. And make
Yes,
sure
Your
you
Honor.
have accounting of where the money
Yep,
goes.
no, none of that. Nope. I will take accountability and none of that's happening.
Yeah, and that goes for the other conservator as well, or power of attorney. All right, if there's nothing further, anyone? All right, we'll be in recess for this hearing. Thank you.